So good evening or good morning, wherever you are around the globe, everyone. Thank you for joining us for this very exciting event on behalf of the Hebrew University of Jerusalem Faculty of Law and the Fetterman Cybersecurity Research Center. We're very happy to be hosting this symposium for the Jerusalem Review of Legal Studies, discussing the phenomenal book by Ryan Abbott, The Reasonable Robots. I'll be introducing Ryan later on, alongside all of his merits. We will be doing this in a format of comments and a response by the author. So we'll have our extremely wonderful panel of commentators start. I will be presenting each of our commentators one by one. Unfortunately, we will not be having Professor Jules Coleman with us today due to some personal circumstances. You will be able to read his comment in the published issue, so that's fortunate. So a few technical notes. We are doing this virtually from Jerusalem and from Israel. These are turbulent times, but we're very hopeful that things will be calming down very soon. Hopefully there will be no unnecessary and unfortunate interruptions. And we can proceed with our first commentator for this evening, who is Professor Ryan Calo, who probably does not really need an introduction among our audience here, but just for the protocol, Ryan is a Lane Powell and D. Wayne Gittener professor at the University of Washington School of Law. His scholarship is a leading scholarship on emerging technologies, artificial intelligence, robots, and privacy and technology at large. We're very thankful for Ryan joining us, although he has a very busy day ahead of him. So he'll be commenting first. And hopefully we'll be able to join us for the panel discussion. Ryan, thank you so much. And without further ado, the floor is yours. So please go ahead.
Thank you so much. Thanks everybody for inviting me to this. I'm delighted to do it. I'm actually, what I'm doing when I pop off is I'm giving a lecture to honor Ian Kerr, who is another absolute giant in the field of emerging technology and law, and someone known to many of people on this call. And nothing short of that would take me away from this discussion. So thank you very much for inviting me. Thank you, Ryan, for writing this great book. And I'm delighted to be able to comment a bit here and then turn it over to the other commentators. So I really like this book. I thought it was. What I liked about it was that it was so sober-eyed about the technology, that it was focused on the immediate and the near-term displacements of robotics, that it embraces a kind of pragmatism, right? That actually underpins, I think, a lot of great American and European and foreign in general, Israeli certainly scholarship, where there is a pragmatist tradition that Ryan is hewing to here, both in the sense that he's trying to make the world a better place, but also his deep functionalism about how to create legal categories. And so I really appreciated that very much. And it's very ambitious to write a book that spans so many different legal domains. I feel like I get out of my lane just, anytime I leave torts or administrative law or privacy law, perhaps, I feel like I'm out of my lane. And he really showed mastery of a bunch of different legal areas that are quite different from one another. And so I have two kinds of but no one ever, sort of, that can't be, I can't stop here and just be like, it was a great book, thank you for having me, right? So I have to say something constructive about it. And I have two kinds of comments. One of them, it has to do with it being a bit unclear in the book what the underlying normative baseline is here. Okay, is it the status quo? Is it a redistributive agenda? But having read the comments of the other of the other participants, I'm just gonna leave that one there because they really ably between them cover that ground. But that's something that it does jump out at you. You wonder what the normative baseline might be for the prescriptions in the book. And so what I want to talk about is the second thing, which is I'm just not sure there is any such thing as a legal neutrality between people and things. Okay. And so what do I mean by that? I was reading this book, Ryan's book, I mean, alongside Kate Crawford's book that's called Atlas of AI. And one of the things that Kate dramatizes is how much of AI is really obscured, and that AI is really built upon this system that is full of materials and energy, I mean, and data and people, you know, that AI is not a thing, right? And so Ryan is careful to do some definitional work up front, and I largely agree with it. But at the same time, I still think that he's a bit, that the book is a bit guilty of what Kate calls enchanted determinism, which is the idea that AI feels like, you know, you make a passing reference, Ryan, to the Sorcerer's Apprentice, but you know, you know, but at the same time, like AI has this quality where it just feels magical and inevitable, and it feels like it's disembodied, and it's this sort of magic that you can apply to multiple different domains. And I know you try to resist that impulse by grounding it in the now and by defining the technology, which really does help things. But at the same time, like you have to acknowledge that, you know, when you're trying to talk about treating two things neutrally, we have to talk about the fact that those two things are so different from one another that exercise is very difficult. And so there's two basic senses, right? So the one of them is that if AIs have bodies, these bodies are made of like rare earth elements. They require enormous amounts of energy. They require constant maintenance. They're bodies that include other people in them at various points. And you know, when you do something with people as opposed to AI, you know, you don't have to like sink a group of people under the ocean to absorb their heat like Microsoft has done with its AI servers, right? You know, we're not going to run out of flesh quite the same way as we are like literally running out of lithium and superconductors. There's this sense in which the impacts of AI are quite extractive, but also that it is this socio-technical system that has a lot of components that are sort of the impacts of which are missing from the piece. Now, I know the impulse is to say, well, let's talk about this purely functionally. What's the output here? In what ways does this approximate the tasks of people? But if you do that, then I also think you have to have conversations about other things that would sorry, my notes got lost in that reshuffle there of the perspective. Okay. But then if we're talking about this purely functionally, then we also have to talk about other things. Like, for example, we have to talk about pigeons. So like AI is better at detecting cancer than humans, but you know what else can do that? Pigeons. Individually trained pigeons can detect breast cancer from images in 85% of the cases. And when they're flocked together, they have AI like 99% accuracy. Why does any of this matter? I'm talking about lithium, I'm talking about pigeons. Why does any of this make any difference, right? Well, it matters not only because it feels weird to say that we ought to be holding pigeons to like a medical malpractice standard. We understand pigeons aren't doing anything, but rather that people are doing things with pigeons. But I think the deeper and more important insight for this book, Ryan, and for your work going forward, is that law really had people in mind. And so one way to think about that is to say, imagine there's an AI built in 2025 in the United States. Well, it can't be president until 2060, right? And it has to be in the United States for 14 continuous years. Why? Because the assumption is that, you know, that it's like a person. And so even though it's immediately available, it has to wait. And what is true for the Constitution is also, in my view, true for things like tort law. And so for me, I struggled to understand how it could be coherent to apply negligence directly to AI or strict liability. Not because you can't measure whether the output of the system was reasonable or not, because I agree that you can, but because of doctrines like proximate causation that are about the foreseeability to the perpetrator of the ultimate thing, right? I mean, and so if you just say to yourself, well, I'll tell you what, we're going to apply, negligence neutrally to AI and people, but we're going to change negligence for AI to dispense with proximate causation, or we're going to change criminal law to play fast and loose with mens rea, right? We're going to alter the character of these laws profoundly in order to produce a supposed equivalence. I think that just distorts, distorts the law too much, right? That is to say that when you go to apply a law for people to things, you have to make such profound changes that criminal law is no longer criminal law and tort law is no longer tort law. Now, I understand that one way to think about this is to say what we're doing is we're just adapting the tools that we have lying around in order to have some kind of consequentialist result we like. But then that does bring us right back to the centrality of needing to articulate the vision of human flourishing that you're trying to advance, right? And so it destabilizes the notion that there can be legal neutrality, because once you apply the law into the different domain, I mean, I was thinking about it. I was it's sort of like applying an eye for an eye to, like, with a race of cyclops, or with a Texas salamander that doesn't have eyes. You know what I mean? It's just like it's so hard to translate these legal insights that are built on the physicality and mental states and so on of people, and then turn them over. And so, so while I really deeply believe in the project, and I thought the analyses were, mostly right, I do think that we're much more in the realm of legal fictions than we are in the realm of legal neutrality, because of the calisthenics that needs to be done to apply these human-based concepts to objects. And so those are my remarks, and I'm very excited to hear Ryan's response eventually, which I'll catch on in recording if I don't get it live, and to hear the other panelists. But thank you again very much for including me.
Thank you so much, Ryan. That was great, and hopefully we'll hear more from Ryan Abbott on these topics in his response, and maybe discuss this in the panel going forward. And next, we will be having Professor Carys Craig. Carys is a law professor at the Osgoode Hall Law School in Canada. She's a leading IP scholar and emerging technology scholar. Her work focuses recently also on artificial intelligence, and especially in the realm of artificial inventorship, which is obviously very relevant to some of Ryan's arguments here in the book. And Carys, please, the floor is yours. We're excited to hear your comments.
I had to find my unmute. Sorry about that. Okay, here we are. And I can see the wrong Ryan on my screen. Not that you're the wrong Ryan, Calo, but okay, there we go. So first of all, I just want to say thanks to Omri and Ohad first for the invitation to participate in this discussion, and for their excellent organization and perseverance actually over the last little while. I mean, I think since they began planning this, we've been through a period of time that's far more fraught than any of us could have anticipated. So I really appreciate the fact that they've gone to the efforts to bring us together today. And I also, of course, want to thank Ryan, the right Ryan, Abbott, for giving us such an enjoyable and readable and thought-provoking book for us to really get our teeth into. So I'm really excited to be here for the discussion. So Ryan's book is called The Reasonable Robot, and in my written comments, well, I've called them the relational robot. and I'm proposing a more normative lens for legal neutrality. So as you'll see, my point is ultimately that to suggest that Ryan's principle of AI legal neutrality lacks the sort of necessary normative lens that we really need, I think, at a moment like this to inform good AI policy making. So although there are like several points along the way where I am convinced by Ryan's sort of particular prescriptions for law reform, and even in the patent and IP chapters that I focus on, my comments, I think that's true. But nonetheless, I think we nonetheless disagree, and he knows this, at quite a fundamental level, just about the theoretical frame that we should be employing to inform the law's response to the arrival of AI and to sort of law and technology questions more generally. So that's where I'll get to, but before I do, let me back up a wee bit. First of all, there are a few things we agree on, right? I like the driving force behind the book's thinking, that we need a thoughtful and a deliberate response to AI, and one that focuses on the functionality of machines, on consequentialist benefits, and that uses law in a practical way to try to advance human welfare. So certainly the hope that I see in the text is that we might be able to get through this latest sort of industrial revolution, you know, in the right way, and try to use this functional approach to inform sensible lawmaking that actually ensures that we get the greatest social benefit out of the new technologies, that in Ryan's terms, we optimize the law for AI, and certainly we have to recognize that AI is stepping into roles that have traditionally been performed by people, and we have to respond appropriately to this and recognize it as an important sort of technological shift, right? So far, so good. But Ryan also thinks that neutral legal treatment would be, at least in many cases, the thing that ultimately benefits human well-being by helping the law to achieve this underlying policy goal as the AI shift occurs. And so, as you've heard, he's proposing that this would be the optimal kind of legal default principle, that the law should not discriminate between AI and human behavior. And the presumption is certainly proposed as just that, a presumption in favor of neutral treatment. So it's not dispositive, we're told. It may be departed from when there are good reasons for so doing. And because Ryan kind of brings a law and economics frame to the problem, the reasons for tweaking or departing from that default are typically presented as being sort of efforts to ensure appropriate incentives for more efficient or socially desirable outcomes, right? And he also acknowledges that there are other values at play, things like transparency and accountability, that have to be part of the policy balance on a case-by-case basis. So fair enough. But my concern is with the principal default position, right? And whether that in itself has enough sort of normative heft or credibility even to justify anointing it as the default. Because defaults, I mean, they're not dispositive, of course, but they are hugely important, right? And so this is where I turn in my comments to the work of our dearly missed friend and my co-author Ian Kerr, who wrote a piece in the 2017 Critical Analysis of Law journal called "The Devil is in the Defaults." And Kerr wrote, once defaults have settled, opposition to their usage is increasingly difficult. Expectations tend to consolidate in favor of their use. Normative defaults can lead to a hardening of categories such that it becomes more difficult to do otherwise, right? So legal and normative baselines establish presumptions from which any sort of departure or deviation has to be justified and has to be defended. And exceptions then have to be like hard fought, and they tend to be narrowly drawn, right? So I think we need to be really wary about establishing defaults that set us on a policy path, especially for the sake of like optimizing efficiency, that might run counter to other social values, to principled objectives, and that actually could quickly become an obstacle to those principled objectives, to responsive decision-making that might be guided by those other, potentially conflicting values, like, say, equality or human agency, right? And rights, when there is an economically valuable interest, have a way of sticking, right? Once they're granted or once they're assumed, they're really hard to retract or to dislodge. Right? So Ryan's his idea of AI legal neutrality supports extending rights to robots only when it benefits people. But which people? And what happens when the calculation changes? So I write in my comments that legal defaults quickly become stubborn dictates, and efficiencies predictably morph into perceived entitlements. And I actually think that intellectual property rights are the perfect example of this, like the perfect example of an efficiency rationalized right that, no matter how counterproductive they might become, have just stuck and have grown and accumulated and consolidated corporate power, even and often to the detriment of public welfare. So I'm going to turn now and think more particularly about how Ryan's arguments play out in the sphere of intellectual property to kind of show you what I mean. So in chapter 4, Ryan applies his approach to the challenge of AI inventorship and patent law. And as he explains, almost every jurisdiction requires that a patent application lists an actual person, a human being, as the inventor. So he argues that patentability of AI-generated inventions should be based on the inventiveness of the AI's output and not its status as non-human. And this is the functionalist solution, right? It's based not on, he says, not on a clumsy anthropomorphism or a misplaced commitment to the trope of the human inventor and his flash of genius. AI inventorship should be enough. So if we accept for now that patents stimulate investment in innovation, I won't quibble, and if it turns out that AI excels at generating novel and useful inventions, often beyond what humans are capable of, then I can agree, like, it might make good sense to incentivize AI-generated invention through our patent system. But I do, and I can't resist raising a couple of other wee quibbles here just in passing. And I think they're pertinent because they're not based on any kind of romantic commitment to the idea of a human inventor. They're really just within the economic frame that Ryan offers us, right? So first of all, as I see it, granting monopoly rights over inventions imposes a social cost. And it should only then be done in the economic logic if the benefits outweigh those costs. I don't think we should assume, based just on armchair economics, that there's currently a problem of underproduction or underinvestment in inventive AI. Something like there's a problem that we need to solve by awarding more monopoly rights. I'm not convinced either that the cost-benefit analysis looks the same for AI-generated inventions, right? Given the scale and the rapidity with which AI can generate outputs once it's been trained, and given the fact that, like, the AI creator might already enjoy copyright in the software code, might already have a patent in the AI as an invention itself, maybe there are already enough incentives in place. As Mark Lamley suggests, we grant patents to encourage inventions we wouldn't otherwise get, right? So it seems to me that in the absence of a problem to be solved, the default position should be not to impose the social costs of a patent monopoly. And here I also invoke like James Boyle and others who've written about the public domain, just saying that the public domain itself should be the default. So if Ryan's proposition is that, if AI generated inventions are to be prohibited, it should only be on the basis of sound public policy, otherwise they should be in. I say that if AI generated inventions are to be protected, it should only be on the basis of sound public policy. Otherwise the default should be that they're not. Okay, so we might find it, I think, in time that patent protection is unnecessary, or we might find that a more carefully tailored sui generis protection would be optimal. So something with shorter terms or more limited scope, or even, and better, something with regulatory conditions attached to it, like disclosure and transparency and ethical deployment and other things that might serve the public interest if we withhold the benefits of the monopoly. Okay, but all of this is kind of actually a digression, because my main point here is actually that even if Ryan's right about what makes good AI patent policy, I don't think this necessarily supports the broader principle of AI legal neutrality. And in fact, I think his conclusion here seems to flow more readily from the starting point that that neutral treatment in the patent realm would be consistent with the purposes of the Patent Act and advancing progress of science and the useful arts. And that's something I think we should talk about, because I think this is where we should begin the analysis, right? With the normative objectives of the law. And again, this matters because where we start is important. Defaults are important. So the AI legal neutrality default supports this presumption in favor of protection. And then if there are good reasons to depart from the default, that's fine, but who's to make the argument against it? Who's going to dislodge this presumption in favor of protection? So we have to think about how in reality, like, there are powerful economic interests that will align with more protection for the AI owners. Ryan notes that they're likely large enterprises with sophisticated lawyers. Right? So we're conflating these already powerful corporate interests with the interests being served by AI legal neutrality, and being told that this is all in the name of advancing public welfare. So I don't know, but I think if we begin by asking what will best advance the objectives of patent law, then those seeking protection for AI generated inventions have to demonstrate that it's necessary to advance those public policy objectives that they be protected, right? The onus is on them to dislodge the presumption that exists in favor of the public domain. That would be fine. So I guess even if Ryan's right about the optimal policy response here, in terms of the sort of dynamics of law and policy making and power, it really matters a great deal how we get there. All right, I think the problem becomes even clearer when we turn to look at copyright law and the question of so-called AI authorship. So here, Ryan's focus is on patents, and he puts copyright together with patents under the umbrella of intellectual property, which is always a category that kind of obscures more than it reveals by grouping together things that are really not the same. And then in thinking about the non-human inventor, he's looking for guidance to the treatment of non-human authorship in the copyright sphere. But I really worry about this sort of inventor-author analogy, because I think it blinkers the analysis to these vital differences that, if we were taking a purposive approach, would lead us in entirely different directions, right? So applying AI legal neutrality, both AI inventorship and AI authorship should by default be treated by law just like human inventorship and human authorship. And I disagree. So I've written and argued elsewhere here together with Ian Kerr that the whole idea of AI authorship is oxymoronic, right? The authorship is not simply about the production of original works, and as many as possible. Rather, it's a dialogic social practice. It's a relational kind of act of communication. And Ian and I suggested that authorship in this sense, in this sense is beyond the reach of AI. The AI just lacks expressive agency and it lacks the understanding to engage in any kind of dialogic exchange of meaning. Okay, so, we know that AI generated works can be facially indistinguishable from works of human authorship, and that legal systems could really easily accommodate them if we decided, that they should. But the mistake we absolutely should not make, we argued, is to treat the AI as an author, that this is a category mistake that misunderstands the ontology of authorship. So we argued that good copyright policymaking has to begin by recognizing that AI-generated works and human-authored works are fundamentally different in purpose and in kind. So Ryan's principle of AI legal neutrality would have us treat them as if they're equivalent or as if they're the same for the law's purposes. But I think if we start by looking at public policy purposes of copyright, that's going to lead us in a different direction. So the purpose of copyright, I would say, is to encourage the activity of authorship as an expressive act of creative agency, not just to maximize the production of works as outputs or as things. And this is actually closely connected with another sort of notion that copyright is an engine of free expression, right? Even the Supreme Court has said this. It should be advancing then and reflecting the values inherent in the right of expressive freedom. So seen in this way, the policy goals and the social values that justify granting rights to authors over their works are just not the same as those that would justify protecting AI-generated works. And so to presume that we should protect them as if they were the same is, I think, at best just a sort of unhelpful default, but probably worse than that, probably a harmful one that will actually undermine authorship and free expression. So different IP systems protect different actors in respect of different subject matters. They serve different public purposes. And I just don't see any reason why we would assume that applying legal neutrality across the board is going to advance the same social values or the same normative objectives that underpin the law. So why would we start there? Why would we not start by asking what legal rights and responsibilities would advance the objectives of the law? And the social values that the law is taken to represent. So this takes me to my last point, really, about sort of the concept and how we conceptualize legal neutrality in the face of changing technologies. And it's something that I've thought quite a lot about in the copyright context in respect of different conceptions of tech neutrality. So, as I understand it, and Ryan explained it well as well, other Ryan, is that that Ryan Abbott's approach is largely concerned with prescribing neutral legal treatment to functional equivalents, right? Actors that do the same thing or actions that produce functionally the same effect should be treated the same. So elsewhere, I've kind of characterized this as an intermediate approach to neutrality on a kind of spectrum that ranges from a narrow approach to a more expansive one. I won't bore you with the details. A narrow approach sort of strictly applies the formal law as it is to new technologies, looking at their sort of internal mechanical operations. So it's more formalist in that sense. The intermediate approach is better because it does focus on sort of functional effect and functional equivalence, but it still has, I think, normative shortcomings, right? So here are a few. First, I worry that the use of analogy to compare activities can just be misleading. Like it can cause us to overlook differences and potentially obscure larger real paradigm shifts that the technology provokes. So it's kind of a willful technology blindness, right? When I think what we need is precisely to be alert to the changes, to the disruptive force of technology, to the disadvantages that it sort of produces or reproduces, to the substantive differences that it's making in our lives. Second, I think the approach is too rooted in the status quo. That in this sense, it kind of sets our normative ambitions too low. So I wonder why we would settle for imposing the same norms and standards on AI as we do on humans. Why would we not expect more, much more, of systems that can be designed to improve the human condition? Especially when morally there's no objection to treating the machine, unlike a person, as a means to another end. Thirdly, I worry that the focus on functional equivalence feeds our tendency to forget what machines are and what they are not. So we talk about robots being reasonable, when they have no capacity to reason. We talk about them owing a duty of care when they're incapable of caring. We talk about them creating original works of expression when they're unable to actually express anything. And so this is a kind of categorical blurring or confusion that produces, I think, bad policy making. And finally, you know, I caution against how this approach might obfuscate the roles and the responsibilities of the humans that are actually behind the machines. And this goes to what Calo was saying before, that when we treat AI like humans, we risk sort of displacing or disguising the actual human actors and their corporate organizations and their power structures behind this sort of cloak of really false equivalence. So these are the risks, but what's the alternative? I offer just in conclusion a brief sketch of what I think is maybe missing from this AI legal neutrality principle. So the normative lens that, you know, I would like to bring to it if I was writing the book. I think, you know, I said that Ryan's approach was an intermediate one on this like tech neutrality spectrum. And I prefer like the expansive, more substantive notion of technological neutrality, which focuses instead on the normative objectives of the law. So the question we should really be asking is, you know, given the realities of the new technology, what rights and responsibilities should the law recognize in order to maintain its normative equilibrium or balance, or to continue to advance its underlying policy objectives? So the default is really kind of normative neutrality, like the law's purposes or its objectives are presumed to remain consistent as technologies change them. And that might mean that we need to adjust old rules and treat new technologies differently, or we need to recalibrate the system or even completely reimagine legal doctrine in response to real game changers like AI. The last thing here is that the focus shifts from individual actors and individual things to the relationships that the law constructs through legal rights and responsibilities, right? So the suggestion is that legal relations should reflect basic human values, human agency, autonomy, and so forth. And that the law should then be concerned with shaping human AI relations in a manner consistent with these values, a way that fosters these values. So we should be thinking purposively about the relationship between AI and humans. Like, what do we want it to look like? What functions should it fulfill? What human capabilities should it be fostering? And, you know, I think in some circumstances, this might ultimately lead us to treat AIs like humans, as Ryan proposes, but it needs to begin by recognizing the sort of unique dynamics of human AI relations and the social values that are at stake. Those relationships might look functionally equivalent, but substantively, they're really very different. And we should be looking at the AI not as if, but as it is. Okay, so to conclude, it could be said actually that the idea of the reasonable robot already entails this kind of approach, right? The reasonable person in tort law is not an individual actor, but is actually just a heuristic device that we use as a sort of principled normative standard that we bring to bear on our social and our commercial interactions with one another, again, to kind of foster and maintain the kind of society that we want to live in. So I think the reasonable robot concept could do the same, could perform this kind of role as a normative device. So the ingredients are there, but ultimately I suggest that Ryan doesn't put them in this sort of basic recipe for AI legal neutrality. That principle asks us just to start with neutral treatment of AIs and humans and reason backwards to justify differential treatment as an exception to a default norm. And he's right that defaults can be helpful, that we need a functional approach to AI regulation that aims at public welfare. And Carys noted the future is full of question marks, and we need default rules. They fill the knowledge gaps that may arise in future dealings. But I think Ian was also right to caution that the devil is in the defaults. And here it just seems to me that equal legal treatment of AI and human actors is a pretty risky default setting. So thank you very much for bearing with me. I'll stop there and I look forward to hearing more from you.
Carys, thank you very much. This was wonderful and thought-provoking, and I'm pretty sure that the idea of the normative power behind our future AI regulation will be an important point to discuss in our panel discussion moving forward, because this is a repeating point, and I'm sure that Ohad will touch upon that as well. So thank you very much, Carys. And we'll be moving forward to my dear friend and co-author and colleague, Dr. Ohad Somech. Ohad has his PhD in law from Tel Aviv University, where he's also an adjunct professor, and he is a research fellow here at the Fetterman Cybersecurity Research Center in the Hebrew University of Jerusalem. Ohad's literature and scholarship focuses both on contract and torts on the theoretical and normative levels, as well as law and emotions, hanging on his background in psychology, as well as in recent years, law and technology, and specifically artificial intelligence and its social and behavioral impact. So Ohad will be presenting our joint comment on Ryan's book, and Ohad, please go ahead, the floor is yours.
Okay, thank you, and hello. So, as Omri said, we're facing a bit of a difficult time here in Israel, to say the least. And so it's a real pleasure to see everyone and discuss Ryan's book, not only for the sense of normal life, but you know, it's amazing how Zoom is suddenly part of normal life, but also because it's a truly fascinating book and a delight to read. So I hope you'll excuse me if I'm not always as coherent as I should be under the circumstances. And I'd like to begin by saying that a straightforward reading of the book, or at least my straightforward reading of it, sees it as centered on the idea of AI legal neutrality, which we already heard a lot about. And in very general terms, the book proposes the idea of equal legal treatment of human beings and AI, and then moves to answer two questions. Why is legal neutrality desirable, and how can it be achieved? But what I want to do here, and what Omri and I have done in our review, is to offer an alternative reading, one that places the book not in the tradition of legal writing on AI in particular, but in writing about industrial revolutions and their legal and social implications. And by legal writing on industrial revolutions, I mean, for example, the well-known works by Martin Horowitz, John Witt, and others. And from this perspective, industrial revolutions are a venue of legal and social turning points. So it sees the introduction of a heavily disputed technology as begging the question, are we to reproduce the existing legal and social orders, or are we to renegotiate them? Now, I should also say that there might be something a bit unfair about this account of the book, because it might sound like the typical, this is the project I would have done if I was writing the book. But still, I hope, and I think, and I hope Ryan will correct me if I'm wrong about this, I think that this alternative reading has some grounding in the book itself, and that it's not an entirely external outlook. So to give some background, we focus on John Witt's account in the Accidental Republic, and what Witt shows is that the Industrial Revolution of the 19th century was a time of great turmoil, with much of the attention, and not only or even particularly of legal scholars, but of political, industrial, and labor actors, turned to the problem of industrial accidents. That is the really horrendous amount of deaths and severe injuries, and the social and economic implications to victims and their families that was brought about by industrialization. And more important to our discussion, how this problem of industrial accidents shaped much of our still existing legal and social institutions. So, as Witt argues, after the Civil War, the American ideal was that of free labor, the self-made, self-employed entrepreneur that for contemporaries represented the opposite of slavery. And this ideal of free labor was infused with normative ideas of individual autonomy, formal equality, and independence, which in law meant an emphasis on contracts, because contractual relations were understood as offering both personal choice and personal responsibility. Now, the ideal of free labor still very much exists today, but what the accident problem did was to make at least some people realize its severe limitations. So to understand that people are codependent and that they cannot always or even usually fend off for themselves. And so American law changed with this realization, for example, by shifting from contracts to torts and creating institutions such as workers' compensation and later social security. But, and this is the important point both for Witt and for us, the particular outcome that came about was, it was not inevitable. So it was the result of a long process of experimentation and deliberation among different interest groups and ideas. Or to put it in our terms, the industrial revolution was a time in which our social, normative, and legal arrangements were being renegotiated. Now, because AI is expected to have similar disruptive qualities as the technologies that led to the 19th century industrial revolution, many of the lessons from that period may, and we believe are still relevant today. And so our alternative perspective begins with the realization that work on AI should be understood as part of a process of shaping and reshaping both law and society as a whole, and that any account of the law of AI should be mindful to whether it seeks to reproduce existing legal outcomes in the post-AI world, or does it also seek to renegotiate our social arrangement. And the other two very related insights we wish to underline is the idea of path dependency, that is, how solutions to immediate problems like that of industrial accidents may create entrenched ideas and institutions that would continue to shape our lives long after the problem is gone, and the notion that, at least in this relatively early stage, identifying what will be the main problem that the introduction of AI will bring is just as important or even more important than any of the specific solutions being proposed. So how does this perspective apply to Ryan's book? Implicitly and at times explicitly, the book identifies growing inequality and distributive injustice as the main problem from the introduction of AI. And this is most clearly stated in the discussion of tax law. So as Ryan tells us, AI is expected to unlock great wealth, but it also generates wealth unevenly. And so policymakers should ensure, Ryan writes, that this value is distributed in a socially just manner. And to achieve this in the context of tax law, the book suggests reforms that go way beyond helping those immediately affected by automation. And in fact, it sees the problem with existing tax law in that it systematically favors capital over labor. So as Ryan writes, businesses that automate can avoid employee and employer wager taxes, Medicare payment and surcharge, as well as claiming accelerated tax depreciation on capital costs for automated workers. And the suggested solutions include a repeal of the employer and employee tax, an increase of capital gains, corporate, property, and sale taxes, a revocation of tax deductions for automation, and the creation of a corporate self-employment tax levied for businesses that produce outputs with relatively little human labor. And so from our perspective, both the problem and the proposed solutions are not unique to AI, but they reflect concerns about the American tax system that has long bothered many people. Or to put it in different terms, although AI will significantly increase the inequality created by the American tax system, both problem and solutions are not created by AI, and the book, this to me seems to suggest, should be adopted even if AI would suddenly vanish from the world. And so our reading suggests that AI is not the underlying reason for reform, but more of a catalyst to renegotiate the social arrangements and normative ideas reflected in the tax system. And to a large extent, though, more implicitly, the same goes to IP law. So here, Ryan performs a two-step move, and I'll go over it quickly. First, he argues for the recognition of AI as inventor, which alone would likely increase inequality, but then he suggests greatly reducing the ability to patent innovations. So he writes, once the average worker uses inventive AI, or inventive AI replaces the average worker, and the inventive AI becomes the standard means of research in the field, the skilled person standard should be replaced with an inventive AI standard. And this, Ryan recognizes, means that almost everything will be considered obvious and patent protection will rarely exist. So here too, from our perspective, the problem of inequality created by the existing IP system and the solution of nearly abolishing patent rights were not created by AI. So AI may worsen the problem, but the desire to reshape the IP system to reduce rewards for innovation and place more inventions in the public domain is independent of AI, and the introduction of AI acts more of a catalyst to these reforms. But then things are very different when we look at how the book addresses tort and criminal law. And there the book seems much more satisfied with reproducing the outcomes of the existing legal system. So in tort law, for example, the book suggests applying the negligence standard to AI in a very similar way to its application to humans, that is in effect to reproduce, again, the outcomes of the existing liability system. And although it does claim that when AI would be affordable, the standard of negligence should be adjusted to one of the reasonable robot, when we think about the distributional effects of this change, they seem at least as likely to be regressive as they are to be progressive. Now, of course, because our alternative perspective is only implicit in the book, one does not explain this different treatment in terms of reproduction or renegotiation of the different legal areas, but still we believe that such rationale can be found and that it can be found in the book itself. And that because the problem Ryan recognizes is the increase in inequality created by the added value from the introduction of AI, his solutions focus on those areas of law that control the creation and distribution of wealth, that is, the laws of tax and IP. And on the other hand, when it comes to the costs created by AI, the book seems, as I said, satisfied with reproducing existing legal outcomes and the predicted reduction in overall accidents and harm. And still, we believe that the introduction of AI should be accompanied by a discussion and renegotiation of the distribution of costs as well. So here too, the problems and solutions are not necessarily caused by AI, but AI provides the opportunity to renegotiate the legal and social arrangements reflected in tort law. And one such arrangement concerns who should bear the residual risk, that is the risk of non-negligently caused harm. So one outcome of the first industrial revolution was a shift to a fault-based liability, which places the residual risk on the victim. Now, tort law already experienced some backlash to this in the 60s and 70s with a push to strict liability for consumer products. But the problem of residual risk is particularly relevant to AI because, while both strict liability and negligence create efficient incentives, the question of who bears the residual risk has distributive effects. And in particular, with the possible exception of car accidents, victims are more likely to be individuals, while injurers are more likely to be corporations. So placing the residual risk on victims may shift wealth from the former to the latter. And compared to negligence, strict liability is also more efficient in incentivizing potential injurers to choose the optimal activity level. The optimal activity level. And here too, ensuring that firms are not overly active simply because the law places the burden of non-negligent harms on the shoulder of victims should have a desirable distributive effect. And moving beyond the economic analysis, which seems to dominate the discussion, at least of tort law, the introduction of AI could also be followed by a renegotiation of the very values that animate tort law. So as an example, the move from strict liability to negligence in the late 19th century was not made only for economic reasons, it also reflected balancing the freedom of potential injurers and that of potential victims, and it coincided with the ideal of free labor and the privileging of the active entrepreneur over the passive so-called wage earner. But as I mentioned in the beginning, I think it's doubtful whether this ideal still holds today, or at least whether it still holds in the same magnitude. And today, economic activity is mostly performed not by self-employed individuals, but by large firms. And so the justification for privileging the active economic actor over potential victims seems much weaker. And here I think AI might make things even worse, as even actions on behalf of firms, which were once at least performed by human beings, would now be performed by robots. So negligence will place the residual risk on individuals rather than on corporations and the robots who act on their behalf. And another sometimes forgotten value of tort law is simply providing compensation to victims. And here too, the introduction of AI might increase the number of uncompensated harm, because even if the overall number of accidents will decrease, accidents that do occur are more likely to be for no fault of the AI engine. And let me just end with a final word on innovation, because many people feel that imposing strict liability on AI would stifle innovation, but strict liability could also have the opposite effect. So a significant barrier for innovation, perhaps much more than any legal rule, is gaining consumers' trust. For example, people need to trust AI enough to be willing to give control over their cars and essentially over their lives to a robot. And one way to gain such trust is for manufacturers to assume liability for any harm caused to consumer. Not because paying damages can undo the physical harm, but because it signals manufacturers' confidence in their product. And once we realize this, it may not be surprising that car manufacturers like the president of Volvo already stated that if anything happens, we assume liability. So let me just conclude by saying that at least here we do not propose what the end result of this process of renegotiation should be, but merely that the introduction of AI should allow for such deliberative process to occur. So thank you very much for listening, and to Ryan for his wonderful book. Thank you.
Thank you so much, Ohad. I want to compliment you, but I don't want to self-compliment. So I'll just say that your presentation was perfect. So this was a joy. And now to the man of the hour, Professor Ryan Abbott, and a short introduction is due here. So Ryan may well be a reasonable robot, because he's certainly an unreasonable human being, or an extraordinary human being. He's not only a professor of law, he's also a professor of medicine. He's a physician. He writes on health law, law and technology, artificial intelligence, obviously. And he really is some sort of a superhuman being. And in fact, if you ever need your robot being taken care of in terms of medical treatment, I guess Ryan is your guy. So Ryan, it would be great to hear your thoughts. It's rare, you know, in aesthetics and literature review, we have various approaches to what a work really means, or what a work of art really means. We have the author intent approach, and we have the reader response approach. And here we have the opportunity to have both. We just heard what the readers thought about the work, and we have the opportunity to hear directly from the author what the intention was. And we're very much looking forward to hear your responses to the comments and any other information that you can give us on the motivation behind this wonderful and delightful book. So Ryan, please go ahead. The floor is yours.
Well, thank you very much, Omri, for that overly generous introduction. It is not every day someone is described as superhuman and phenomenal, but I'll take it, and it will make my mother happy. So, first, a lot of thanks are due. Firstly, for a whole bunch of people who have come and been willing to sit through today, which is very generous of you. To Omri and Ohad, thank you so much for arranging all this and going to the tremendous amount of work of writing up these comments, which, because they are good, then I understand Omri gets all the credit for, but Ohad did the most of the slave labor on, so thank you. And to Carys and Ryan, who's had to go, and to Jules, who couldn't be here, but who is providing written comments. Thanks so much for obviously reading the book, and then taking so much time to say, very thoughtful, interesting things. It would have been better, I think, if we had done this before the book got published, so incorporated some of these things, but here we are. you know, a couple of thoughts. My middle daughter's name is Ryan, so I'm used to getting confused by people saying Ryan and not knowing who they're referring to. So I feel, safely at home with this. And, it is, Carys worked with Ian closely. Ryan worked with Ian closely and is now going to give the Ian Kerr Memorial Lecture. In some ways, this whole book came about because of Ian Kerr. When I started at Surrey as a professor, there is a tradition where you give an inaugural lecture. And I was thinking of, coming up with something new to say, but instead, in part due to baby Ryan, decided that it would be a lot easier and probably better all around if I stuck to something I'd already written. So I took my various writings and tacks toward intellectual property related to AI and combined them into an inaugural lecture with Ian introduced, and then we sat together and did kind of a panel on, and that was the genesis of this book. And so now it is a book, and I'm sure Ian would have dug into it even more critically than Carys did, but she did a pretty good job standing in for him. And I don't feel bad about suggesting the book you would have liked to have written. Not only did Carys did that, she even had a title for it and a snazzy PowerPoint. So I wouldn't be surprised to be getting a request to review a book proposal for the relational robot in the not too distant future, but it's got my sign off if the title works for people. I guess to just say a few words about the genesis of this, and then I'll maybe respond to some of the points that were made in no particularly organized fashion. For me, I was largely focused with my scholarship on drug and device regulation and intellectual property, and was teaching the law of inventorship in a patent law class and doing work for a biotech and a pharmaceutical company. And if you don't know this about pharmaceutical companies, you can basically outsource any aspect of research and discovery to contract research organizations, from what drug should we have to be studying to doing our preclinical research, doing our clinical research, doing our regulatory filings. All you really need is a whole bunch of money. And some of these companies were advertising back in 2013, 2014, if you tell us the therapeutic target you're interested in, we will find an antibody that will essentially be the drug you can then try and go get approved. We'll have a computer go through a giant library of antibodies, pick the one you want, and give you supporting data for it. And I thought, that's interesting, because when a person does that at our company or elsewhere, we make them an inventor. But if you just had a machine do that, well, how would that sort of thing be handled? I wonder if anyone's ever thought about that before. And it turns out it wasn't that original. People had been thinking about it since the 1960s. I had some different thoughts about it. But as I looked around in different areas of AI being introduced increasingly to work, I noticed that at least some of the time, an AI was essentially functionally doing exactly what it was that a person did, or at least an AI was predicted to soon be doing functionally exactly the same sort of thing a person would do, like driving an Uber. And so as I, without necessarily intending to originally, went through a few different areas of the law to think about how this sort of thing would play out, my observation was, as Ryan said, the law is often written explicitly for people. And it's not so clear that that works as it is when you start having AI do human sorts of things. So for example, with the AI functionally inventing stuff question, some of you may know that I am working on a legal test case where we have filed 2 patent applications for inventions made without a traditional human inventor. We just had a hearing on this case in the US District Court, and of all the theoretically interesting policy or normative questions one might have about this case, the only question really from the court was, how literally do you have to interpret the word individual in the context of this act? Even though no one was arguing that Congress had thought about this sort of thing when they were writing about it, or, what would the right outcome be? Just, what very narrowly does the law say? We'll see if it ends up getting appealed, they have a slightly different opinion of that. But I do agree with Ryan that, the law is not necessarily AI centric, or I should say kind of written to optimize benefits from AI. And that was one of the purposes of writing this book and proposing this new default. let me start with, let's see. I guess I'll go in reverse order, although there were a couple of kind of overarching thoughts here. Well, let me start with Carys because she had the fancy PowerPoint and I'm thinking about that. So, and some of this ties into two comments from all over, which were, is this book attempting to restore the status quo or to renegotiate a new normative baseline in light of changes caused by AI? And I would say, I don't think that this principle is trying to solve everything. I think it is, one contribution to the discussion and way we look about how best to regulate AI in the same way that we think of a value like transparency. And, transparency is something that by and large we want out of AI systems, but it isn't something that we necessarily always want or something that we need. For example, if you had the example I like to give is if you had an AI that used machine learning to diagnose skin cancer and it was 100% efficient, but you had no idea how it was working and a doctor couldn't understand it versus an AI that was 90% efficient but had a very straightforward expert system based on physician input and physicians knew what it was doing. I think you would far prefer the improved efficiency and outcomes rather than the transparency. Sometimes transparency is obviously a lot more important than that, or a dispositive principle depending on the situation you're in, but AI legal neutrality, isn't necessarily by itself restructuring status quos. It's just a lens of looking at this. And I think I perhaps should have done a slightly better job setting out a distinction between treating an AI and a person the same legally, which the book is not looking to advocate for, as treating AI and human behavior the same legally, or more often doing so. And it is a subtle distinction, but it is often an important one. So Ryan and I were chatting a little bit before he had to go about this in the tort situation, and he argued that he didn't really think this principle worked so well in torts and criminal law. And I'm not sure that I agreed with him on the torts fronts with proximate cause, because again, the way these tests are set up, they are largely objective and not subjective tests. So if I run someone over while I'm driving an Uber, sometimes, but usually not, do we care, to have me as a witness saying, well, it never occurred to me I could have run the person over, or, I thought I was driving at a reasonable speed, right? More often we're saying, would through this heuristic device of a reasonable person who we're kind of going to put ourselves into the shoes of, would a reasonable person have realized that if someone crosses the street and you hit the gas and aim at them, you hit them, that, one thing is likely to cause the other. Or we're asking, was there an actual causation, which is, again, objective. And we're not saying, did someone think what they were doing was reasonable? We think objectively, was it reasonable? And that doesn't require us looking into an AI and figuring out what the AI was thinking. One could come up with a mechanism for trying to do that and analogize it to human thought. As I talk about in the criminal law chapter, it could work, but it's not clear it would be a good idea for a whole host of reasons. So it really is kind of the law focusing more on behavior and having legal standards that encourage us, encourage better sorts of behavior. And that is not about encouraging an AI, but about encouraging the people who make, build, and use AIs to have AIs that are adhering to these behavioral standards. That kind of ties into comments Ohad made on tort and why I wasn't kind of more aggressively suggesting we shift the default to have more burden on AI owners, given they're going to be companies, and isn't it better to hold a company liable than to not compensate an individual? And I think there's a few reasons why I still think a negligence framework is better for this. For starters, it really isn't a decision of, do we want this new AI doing something or nothing? It's a question of, in the cases I'm concerned about, do we want this new AI doing something or a person? And people are sometimes much better than AI and have common sense. Sometimes they don't, but at least for certain sorts of tasks, the AIs already are, or are almost certain to be, in the not too distant future, much better than we are at things. And driving cars is, I think, going to be the best example of this, although the AI is doing all sorts of stuff. You know, human drivers cause 94% of accidents through human error. 1 million people die a year annually, more than 1 million, 300,000 in the US, 3,000 in the UK. That's a lot of people dying from human error. If we have higher standards for an AI and that discourages the use of AI, then we are being left with more dangerous alternatives on the road. And so while I think the answer depends a bit more on math than, as Carys put it, armchair analysis, it seems to me that there is a benefit as long as you're replacing a standard with a safer new alternative in not holding it to the highest possible liability standards. I also think there's 2 more reasons why victim compensation isn't something to worry about so much in the context of AI. One of which is that when you look at strict product liability in the US, you generally need to show not only that there was causation, but there was a defect in the product or a defect in the product's marketing. It isn't actually necessarily always the case that negligence is an easier thing to prove, and it's going to be particularly difficult and cost prohibitive in the case of some AI. So for example, let's say that a self-driving car rear ends your car and damages your car to the tune of $15,000. You would have to prove a product defect by, you know, figuring out what the AI did and how it did it and what went wrong. That is going to be a very expensive, difficult analysis, even aside from trying to get at proprietary data from the AI company. Having a forensic expert figure out what went wrong with the AI is going to cost more than $15,000 any way you think about it. It may actually be cheaper and easier for us to use a heuristic device to say, you know, should an AI-driven car have rear-ended you? Was it reasonable, yes or no? And not think about, well, what could the AI possibly have been functionally thinking at the time? On top of that, you know, tort liability is just one of many ways that we provide, you know, a means of compensation. And it is likely to be the case that it's going to be much easier to get compensation from a commercial product in the form of a self-driving car than from other motorists. We often have problems with motorists in hit and run accidents or being under or uninsured or not having adequate liability to satisfy judgments or adequate assets or insurance policies to satisfy judgments. Some of those things were duplicative, but I think you got the point. Omri already pointed out that there's so much money behind these new devices that a whole bunch of car companies have just said, you know, we're going to be liable for it. Don't worry about it. And indeed, all of the accidents involving self-driving cars today have been paid out very quickly. So, you know, when you get hit by a Google self-driving car, Google is just going to compensate you, and we're not going to have to deal with, you know, a lot of the issues we deal with now. I think on to my next thought, but I kind of forgot why I started talking about that point. Oh, right. So, and then restructuring kind of our status quo thoughts. So some of that is in here. Some of it isn't necessarily. The book is more sort of about how unintentionally having human-centric laws drives us out of status quos in unintended sorts of ways, and that a solution to this is often AI legal neutrality. But that isn't to say that we couldn't make some deliberate adjustments to the status quo. And indeed, AI provides us, if not a mandate to rethink the status quo, at least an opportunity. One of the reasons I do think the case for that is clearest is in tax policy, where it seems pretty clear already that we have massive problems with the distribution of wealth, at least in the United States. And with AI likely to generate a tremendous amount of wealth, but for a relatively small number of people, this provides an impetus to rethink, you know, how it is we're distributing wealth, which in the past few years has only gone in the opposite direction of that. But, you know, again, these are kind of social and normative decisions that are, you know, not mine to necessarily make on my own, but the adverse tax consequences of having human-centric tax laws are clear too, and something the book is concerned with addressing and pointing out that this is also a means of improving upon the status quo, is something that the book does in the tax law chapter. I think, though, that in the tort system, improving the status quo is going to be the introduction of a bunch of new technologies that are safer than people. and, you know, through that naturally improving human safety and welfare through advances in technology. That's something we're also going to get, I think, with intellectual property. So, you know, Carys and I have disagreed about this for a long time. I think it is less about AI. I think our disagreement is fundamentally a lot less about AI and AI's role in these things than just a disagreement about the intellectual property system and what it's for and whether it works in the first place. And right, so people have different views on that, but Carys has a pretty skeptical view of the value of intellectual property. And for sure, if you thought that intellectual property really largely didn't need to exist now, serve the benefits of corporations over individuals, and was just sort of a social ill that should be gotten rid of, well, then yes, you wouldn't really want AI generated output to get protection for that sort of thing either. So that, you know, again, depends on your baseline about what you think about the intellectual property system. I am a little less skeptical about it, you know, particularly coming from a drug development background myself. And to me, the issue is more, you know, well, there's a lot of issues with, say, COVID-19 and IP, but leaving aside some of that, you know, if you had, I'm trying to think of a company that doesn't have a COVID vaccine. So let's go with GSK. If GSK had an AI that they got from DeepMind that they could show a COVID-19 pathogen to, and the AI could sequence it and find an antibody from its library or formulate a vaccine to it, and say to the GSK scientists, all right, here's a vaccine that I very accurately predicted will work. Here's how you could formulate it. Here's some, you know, simulated computer trials. Here's how you design the preclinical testing and the clinical trials to get this approved. In fact, I'll even pre-format patent applications in FDA or in the EU, EMEA filings. Right? And it all worked, and you had thus a GSK vaccine next to a Pfizer vaccine. It really isn't clear to me why you wouldn't want that same sort of thing to get protection. And it seems to me that if that sort of thing couldn't get protection, if IP is the main way in which that business model functions, that you really couldn't have that role for an AI. You know, even though we're not quite there with AI, drug companies are using AI extensively now in R&D and drug discovery. And we are getting closer to the point where you have less clear contributions from people and more clear contributions from machines to what is a socially very useful sort of activity. And if you had laws that said, well, only when a human generates something inventive can it be protected, and if that sort of work is done by an AI, it can't be, I think that creates a whole bunch of perverse incentives. And this does tie back to what it is that someone wants out of an IP system. I think it is a lot clearer with patents than with copyrights that what we really want is socially valuable innovation. And, you know, one can debate about whether the current patent system is one that generates inventions we wouldn't have otherwise gotten, which is indeed, you know, kind of the primary economic rationale for having a system like that. So, you know, maybe that needs some tinkering as it is now, but it isn't clear to me that you would have any difference with that with AI over what people are doing. People have all sorts of reasons to invent things other than getting patents, and do it sometimes. They do it sometimes in, you know, more in some fields more than others, more software than in drug discovery, for example. But not only if AI is going to be a means of generating this innovation, do we want to encourage that, but also to encourage the disclosure of trade secrets. Otherwise, even though these things can get IP sorts of protections, you really couldn't disclose them in the same sort of way. And the patent system is supposed to be a major mechanism for disclosing information for public benefit. You know, the public domain should be the default is problematic if you need to encourage people to invent these sort of things and then to go out and commercialize them. Maybe less so in the copyright area, but again, I think we have a difference of opinion about the purpose of the copyright system, although to be sure, it has lots of purposes and lots of policy goals in it. You know, that's more of a, I don't know what theory to put on it, but we could say more of a Canadian or continental European approach to copyright than a US or a UK one, where in the US you can have corporate authorship in work for hire doctrine. So I can have my book written by GSK, and the US system doesn't have any kind of problem with that. And again, I guess we're We're asking whether it is we want an AI that could make really good music to kind of be custom made to your video, you know, to video games you were playing, or whether we want to reserve authorship for a relational social activity. I don't think, though, that one necessarily prohibits the other. And if we do want the copyright system to be generating a lot of socially valuable output from an authorship perspective, that's something we should encourage. And it doesn't necessarily prevent people from engaging in their own social activities, although that is something interesting to think about too. If, you know, AI has gotten a lot better this year at making music. A couple of things you could go listen to if you weren't kind of tied into this is the Open AI Jukebox Initiative or Lost Tapes of the 27. You can go listen to music that kind of sounds like Elvis Presley or Frank Sinatra or Katy Perry made it. I mean, it's not really that good, but it's not so bad you wouldn't listen to it. And it's better than a lot of music that's on Spotify right now. So if in a few years it really gets to the point where it's like, you know, actually something I'd really want to listen to, that might displace a whole lot of human creatives, you know, not Katy Perry, but we can't all be Katy Perry. I'm still not sure that's a bad thing, though, because I think that then society has a virtually unlimited amount of creative content they enjoy engaging with. And if people can't legitimately make something better than a machine can be doing it, then we should have them doing something else. Or they are doing it for their own enjoyment and not necessarily as a financial activity, and we have so much wealth we don't even care. I still play chess, and I don't play chess because I can beat a machine. I couldn't possibly beat a machine. But there's other reasons for doing something other than beating machines or being economically productive at doing it. That was a whole bunch of random thoughts. Maybe I'll stop there for now.
That's fine. So you addressed many comments, right? And I think we can touch upon a few more things if when we move forward to the panel discussion. So thank you so much for the response and for the book, because it really is a great read. And as we can see, you know, in the past 1 hour and a half, it is really thought provoking and yields many different, you know, lines of discussion. So hopefully we can continue that in the next maybe 15 to 20 minutes. So I'll just say before we pass to the panel discussion, first of all of our audience is more than welcome to join in and ask questions. So this is an open discussion, and you can either hop in and unmute yourself and ask a question, or if you feel more comfortable, you can just type it in the chat box and we'll be able to address. So please feel free to jump in and intervene. And maybe I'll start with pressing on maybe 2 points that were discussed to a certain extent, and Ryan, you responded to them, but I think there's maybe more to discuss. So first, I want to press on the IP issue, mainly on patents, but I think it's also true for copyright. And when we're thinking about the disagreement that you portrayed between Carys and yourself about whether or not the default should be, you know, the public domain or ownership, and what is the effectiveness or the desirability of the IP system generally and the patent system generally. I think in terms of practical outcome, the difference is mainly in the interim period, because if I read your IP chapters in the book, eventually, when we reach to the point where AI is being the standard, right, for innovation, and is supplanting, you know, the standard of a skillful person, right, a skillful human inventor, and it becomes a skillful AI inventor, then basically everything becomes obvious, and we would rarely have patent protection. I think the main concern that you address in the book is what happens in the interim, right? Do we still support AI inventorship to promote the invention of the AI systems themselves that are capable of producing, inventions and patentable inventions, or not? And I think maybe, and this is, I'm happy to hear your thoughts on that, or anyone else's thoughts on that. I think that it would mainly be a question on whether or not this AI technology needs to be specifically designed for creating patentable inventions, or is it just a side, a byproduct, right, a side effect of the advancements of AI technology generally, which, there are many other incentives, right, to create. So our entire world would be, operated by AI for various reasons, not only for, patent ownership reasons, right, for the performance of services, manufacturing processes, etc. And perhaps, the byproduct of this new technology would be that inventors or corporations or anyone engaged in inventorship could harness this technology for the production of an indefinite number of patents. If this is the case, then the incentive to create these new systems, right, these new AI technologies already exists. And there isn't actually any other incentive required to adapt them to the point in time where they can yield an indefinite number of patents, which may benefit society in a better way if they're left in the public domain, for example. So I think we need to press a little more on this issue, because I think that the divide is there. It's not at the end point of the discussion, where I think we all agree that if we remain with our status quo, for example, or if we remain neutral and embrace AI inventorship, eventually everything would be obvious and there would be no patentable subject matter.
Right. I think that's a good point. I think the time frame is very important to think about in this. If we end up having a world in which we have artificial general intelligence, where we have an AI that could functionally do any intellectual task a person could, and it redesigns itself to be artificial super intelligence to the point where it can dramatically outcompete us at any intellectual task, then a lot of the need for these legal systems at all just totally falls away, because one, they will be driving our cars and they will never cause accidents. So it hardly matters what liability regime we hold self-driving cars to at that point. And two, you wouldn't really need a patent system at all, because it would be costless and instant for that AI to invent anything that we want, including a whole bunch of things we don't know that we want. And so indeed, then naturally, I argue the patent system will just fall off, because you wouldn't be able to get a patent on obviousness, and we don't care about the tort system. But this interim period is important for at least a couple of reasons. And it's really not clear when we get there. And some people think that we will never get to something like that, but largely people think this is some uncertain number of decades in the future, right? Maybe we have artificial general intelligence in 20 years, or maybe it's 100 years. So maybe it kind of doesn't even come in our lifetimes, but I see that as something, an outcome that the law should do everything it could to encourage and speed up. Because when we get to AI that does that sort of thing, we generate almost infinite social value from it, assuming we've done it correctly. And two ways that this speeds up is by having, in the context of, say, IP, appropriate policies in ways that provide incentives for people to make AI that does these things. Now, as you point out, people already have incentives to make AI that does these things, because even if regardless of what the tort system was, these companies want to have perfectly safe self-driving cars so they can advertise them as being perfectly safe and people buy them. People want to have super intelligent, inventive AI, because even if you can't get patents, there's still lots of ways you could commercialize inventions from these sorts of things. So it is true that without the patent system, or without whatever tort system we might have, there are still incentives, but providing more incentives should speed up and encourage use of these products along the way in ways that get us to where we want to go faster. Now, whether those extra incentives are worth it in terms of the social cost they generate is, I think, somewhat of an empirical question. But that is really already the baseline of our patent system. Economists would tell you that given an infinite amount of time, human beings will invent really everything that we want invented anyway, and patents don't so much create inventions out of nowhere as speed up the development time frame of things people would otherwise be inventing. And so, you know, it is the current economic justification for patents that they speed up inventions by providing additional incentives. And if there's anything that we want to incentivize and speed up, it's the generation of AI that can make all these things that we want.
Even if eventually what we do is that we sacrifice a big chunk of these eventual things, for the benefit of those developing these new systems.
Well, right. So, in one view, well, there's different ways this could happen. So, for example, the person behind the AI in our legal test case is, a small business in the Midwest with someone who is kind of a pioneer of AI and has been working in the field for several decades. It is possible that, that this won't all be owned by Google and Facebook, but assuming it is all owned by Google and Facebook, you would have, or, to use my GSK example, let's say GSK makes the super AI that can invent in drug discovery and it cures every conceivable disease and is able to patent all of that and gouge people with monopoly pricing. I still don't think that's a bad outcome. I think that's actually a pretty great outcome, because then we have gotten the cure for every disease a lot sooner than we would have gotten it otherwise, or never. They only have protection for 20 years, and, well, theoretically. And while we are thinking about renegotiating our baselines, well, we have a lot of protections built into the patent system that we don't really use in the US, like compulsory licenses. We've never thought as a society that we needed to exercise it, and there are discussions about that around COVID-19 now. I mean, not exercise it in the US. There are compulsory licenses in other jurisdictions, but if GSK cured every possible disease and was trying to charge us $1 million for everything, that may be a time where we do say, the system is not designed to give you quite this much revenue from these inventions. We're going to take action here, and we have the tools to do that now. But even if they did gouge us for 20 years, we'd still have the cure for every conceivable disease, and that seems to me something that we would really like out of a patent system.
Okay, great. I think we have one question from the audience, but I had just another point that I wanted to make and see if maybe your Carys have any thoughts on that. So during our discussion thus far, there are a few notes touching upon the resemblance between the discussion of AI as an as an agent susceptible to legal doctrines and corporations, right? Because the equivalence is it really begs the equivalence. But my question is, or my thought is it really the same? And is it really the same in the sense that obviously corporations are illegal invention, right? They're a legal fiction, but they're it's a legal fiction pertaining to the activity of human beings, right? Collectively through various mechanisms, but essentially the activity of human beings, whereas artificial intelligence is something different. It is not directly tied to the behavior of human beings. And I think that these analogies that are very natural, and we and even Ohad and myself are making this point when we try to compare our current industrial revolution with the 19th century one, which eventually yielded corporate liability and corporate entities as a legal fiction. I'm not sure that this is a real equivalent in terms of what the law could offer us in treatment of corporations, as opposed to the acts of artificial intelligence, embodied or disembodied. So happy to hear your thoughts on that, and we can then turn to Harumi's question in the chat.
Great, and
we have Ryan Calo with us back. So Ryan, hopefully the keynote went well, and thank you so much for coming back for the panel.
Glad to be here.
Oh, well, it was good timing Ryan came back, because this was kind of one of the second major points that he made we could get into. Ryan, I masterfully dispensed with the first point that you made and got a applause from the audience, but we can.
It's on record, so yeah.
It is. That's right. He'll see the recording of it. these are great questions and issues, and Ryan kind of raised that also, particularly in the context of, talking about how it is that people and machines differ from, embodiments and sorts of embodiments and the systems behind them. I think, as you point out, a corporation is in many ways analogous to an AI, but in some ways it's not. An animal is analogous to an AI, in some ways it's not. A person is analogous to AI, in some ways it's not. And one really kind of has to think through, what one gains from these analogies and where they're appropriate. For example, the criminal law chapter talked about, was perhaps the chapter that got into these other chapters. Were thinking about the law very functionally and about AI versus human behavior, not really about AI and humans as actors, right? Criminal law is a little different because criminal law is less functional, or at least less utilitarian than other areas of the law, where with IP, we want inventive output. With taxes, we want to promote economic activity and distribute wealth. With torts, we want to prevent accidents. Of course, we want a lot of other things. Criminal law is a lot less explicitly about generating good outcomes and a lot more explicitly about why someone did something, with culpability and retribution being key characters of that law. And so it's not just, did you run me over with my car? Was it objectively reasonable, right? That might be a tort, but did you intend to run me over with your car? Or were you doing it with just such an utter lack of disregard for me that we're going to think that you had some sort of bad mindset? In which case it really seems a lot more challenging to bring AI into this, where we don't really think about AI as having a lot of these characteristics that would lend it to a culpability or retribution framework. One of the things the book talks about is, well, it wouldn't be that radical of a legal departure doctrinally to even treat an AI actor as being criminally liable, as opposed to criminalizing AI behavior, because we do criminalize corporate behavior, right? Not actors or agents of a company. We actually find corporations, which are artificial persons, criminally liable for things. Of course, we do that under a, imputed mindset of a corporate agent theory, but still. We also have strict liability crimes where you don't even need to have a mens rea or a guilty mindset with certain sorts of, often very hazardous sorts of activities. You can even have criminal liability based on an omission to act where there is a duty to act. So holding an artificial person criminally liable in the absence of mens rea for a failure to act is something that the law already can accomplish and does accomplish. Whether or not, though, that would be a good idea, I argue no, because while there could be benefits to holding an AI criminally liable, there would be a lot of costs to doing so, including eroding trust in the law and, changing our perceptions of AI and putting it on equal grounding with people. And then also, all the benefits that you would get from holding an AI criminally liable, you would really get from holding a person civilly liable for that AI behavior, probably in better sorts of ways and without all the dramatic sorts of costs associated with that. Similar to holding an AI as more of an actor on a tort liability framework and saying we're going to hold the AI itself liable. Well, yes, you could do that, and I could construct an argument for why it might make sense. On the other hand, it would almost certainly be much more efficient and better to just say, this is a this is a commercial product, and while we are going to objectively look at the AI's behavior and ask whether it was a reasonable sort of thing, ultimately Volvo is liable for what it does, and giving an AI an insurance policy doesn't really seem to have many benefits and just a whole lot of cost and complexity that we don't really need. So when you were asking, is a corporation really an appropriate analogy for an AI? I think the answer has to be sometimes and in some ways, as with animals and people, and it has to be thought through. In the inventorship discussions, the law is fairly well established, although now people, in light of the test case, are kind of reopening this discussion. A company can't be an inventor. And companies would like to be inventors because it's a whole lot of hassle to track down human inventors and get them to sign things, and they leave businesses, and it's incredibly costly and complicated and probably largely unnecessary. In Israel, for example, it's one of the very few jurisdictions where you do not have to list an inventor on a patent application. A company can apply and be an inventor, or sorry, just be an applicant and leave inventors out. But there are some good reasons for, for this rule, mainly that I'm an inventor on a few patent applications and I have no economic rights associated with any of them, and companies own the patents. But still, I invented something. I, feel like that's acknowledgement that I deserve, and that is acknowledgement that benefits me in terms of signaling productivity or future job prospects. But a company is different than an AI in the sense that companies are literally made up of people. And so, even though a company may own a patent, there always had to have been some person at the company who actually invented something. An AI is different than that, because while there are people who built an AI and maybe told it to solve a problem and maybe interpreted its output and maybe are inventors under some circumstances, in other circumstances, there's literally no person who traditionally meets inventorship criteria. And so quite unlike a company, the AI has really stepped into the shoes of a person and done the human thing we traditionally think of, in a way a company can't. So that was, again, many minutes of me rambling, and I think maybe I answered the underlying question, but if I didn't, I can, go back to rambling.
No, you definitely did, and we can maybe hear some more thoughts on that later. I'll just say that you keep mentioning the analogies for AI. So we said corporations and maybe animals. I must say, as a father to two very little girls, one is 3 weeks old, I think babies and children would be a very, very good analogy for artificial intelligence. You can actually see the learning process in your own two eyes. Any parents in the audience would probably relate to that. So. And by the way, maybe it tells us something about liability in terms of tort, but just a side note for that. So let's take that Harumi's question from the audience just to say it out loud. So Harumi asked, what are our thoughts about IP infringements made by artificial intelligence, or in the process of training or designing an artificial intelligence system, specifically with respect to IP protected data that is used for training purposes? Is it fair use? Isn't it fair use? Is it an infringement, and who is liable? And just as a side note for that, there is a recent article by Mark Nunley and Brian Casey arguing that this should be fair use for various reasons. But I think this is an interesting point for discussion. And Ryan, happy to hear your thoughts, and any other panelists are happy to join in.
Sure. Well, these are some of the key issues on AI and IP that people are working through right now. I think they are really kind of two very separate issues here. One is infringement by AI. If an AI is using otherwise, say, copywritten material, whether that's infringement the same way it would be if a person was using it. And the other is using IP to train or develop an AI, which is really a person using it to train and develop an AI. Right. And there are more kind of narrow answers to that questions depending on the jurisdiction about whether this is or isn't infringement. I suppose here the more interesting question is whether it should be infringement. And I think, as with many areas in which we deal with this, that requires a return to kind of what we're looking for out of an IP system. There's a good argument that, there should be exemptions to text or to training AI with this sort of data, because in most cases, the IP wasn't generated with this sort of commercial exploitation in mind. It's not being used in a way that we traditionally think of as exploiting IP or infringing on IP. And there are, benefits from using IP to make AI in this sort of way, and that we're generating these socially useful sorts of AI. So those would be the arguments for saying, training an AI shouldn't be considered IP infringement. Technically, it almost certainly is that there's a copying or use of protected IP. People who are generating these IP would say, well, it kind of doesn't matter the actual use you're putting into and whether I thought of that in the first place. I generated the IP, it's my protected thing, you should be paying to use it. And so different jurisdictions are kind of are feeling out whether or not, again, in continental Europe, you'd have to have kind of narrower statutory exceptions written in for this, or whether in the US it could fall under fair use principles. I think some of these are open questions and kind of fact specific. As to whether an AI using IP should be infringement, well, I think the answer to that should generally be yes. If it was something a person was using, an AI using it for similar purposes should probably be infringement. Of course, as with AI inventorship, the AI itself wouldn't be liable for that because it doesn't have legal personality, wouldn't be influenced by the prospect of an infringement lawsuit, wouldn't have assets to satisfy that sort of thing. You would need to impute that sort of behavior to an AI's owner, or, you know, under some circumstances, a user and developer, you know. But again, sometimes it's fact dependent on what exactly it is the AI is doing. You know, is it using a bunch of Katy Perry music to make a new Katy Perry song, or is it, you know, doing something a little less commercial than that? But again, we have our grounds for people falling outside of infringement, and I think that largely applies to AI activity.
Thanks, Ryan. Carys, Ryan, Ohad, any questions or thoughts you have in response to, you know, Ryan's ongoing answers to our questions? I think that's you know, that would be a good point.
Well, I was going to add, I see that, so I don't disagree with Ryan's analysis there of like what would amount to infringement, what ought not to amount to infringement, the challenges of finding responsibility either with the owner of the AI or the user of the AI if what is produced by the AI is a substantially similar copy. And so I think this is where you can see that when it comes to kind of practical solutions and the application of legal doctrine, just in terms of what makes sense as a policy outcome, we might agree. But I just think there are, again, like different ways to get there. So if you take, I mean, if we look at the neutrality concept as the framing device here, like that narrow view of tech neutrality I was talking about, narrower than what Ryan brings to bear. But that's the one that's inclined to just say, well, a copy is a copy is a copy, right? And we look inside the machine, we lift up the hood, we see if copies are being made, and if copies are being made, then we treat them as reproductions and we apply the law accordingly until the legislature decides to do otherwise, right? Like that's the sort of narrow, you apply the rule to the technology. When you get to sort of thinking about functional equivalence, then it makes the analysis a little bit more interesting because you start saying, like, you know, is this action by the AI equivalent to when a human does it this way? And would it normally be caught if a human does, and should it therefore be caught now? But I still think the best way into it is to say, well, what would be the ramifications of protecting the text and data going in to the extent that we find this to be an infringement? And would that be conducive to advancing the purposes of the copyright system? So if, you know, by saying that a copy is a copy is a copy, what we're doing is we're actually making it virtually impossible for people to train AI effectively because there's no access to affordable data sets. And so we're skewing the development of the technology in potentially harmful ways. Then you have your reason for not treating it like a copy, right? You don't have to work through the sort of application of the doctrine. You're just like, this would produce a result that is contrary to the public purposes of the system. And so we should find a reason why we would exclude this from the sort of reach of copyright infringement. And, you know, I agree that that could be done through the creation of specific exceptions or through a broad application of fair use. But in this context, I think the better thing is to say it doesn't implicate the right. It shouldn't implicate the right in the first instance because it isn't a copy, because we're not concerned with the technological processes. We're concerned with where it fits in our copyright system. But
yeah, go ahead. Sorry.
It was kind of branching off to something different. So if you want to jump in on
yeah,
that.
just say that we also need to acknowledge that, you know, choosing, you know, this rule would have distributional effects as well. So if we do choose, if our underlying, you know, normative principle is saying, well, listen, we mustn't stifle innovation. We need to promote AI, you know, technologies, and therefore we need to exclude potential infringement of intellectual property protected data as part of training processes. We need to understand that while this might be desirable, it shifts wealth, right, from owners of currently protected intellectual property to the future developers and inventors and authors of the new technology. And again, this comes back, Ryan, Abbott, to right to the discussion on, you know, what is the end game here? Who do we want to support in this interim position of, you know, evolving into an AI-dominated, you know, era? Whether we just want to streamline the process and, you know, shift with the concern of shifting the wealth to the to the corporations dominating this specific technological field, or do we want some more let's say conservative approach or cautious approach, taking into consideration the wealth balance as it is today, just as a complement. So Carys, please move forward.
Oh, so I mean, I think the other thing, this is maybe more responsive to Ryan's initial comments. So sorry if that's taking us in a different direction, but it occurs to me, I think Ryan's right that we just actually disagree about the purposes of IP and its significance, and whether it does what it's supposed to do well. And I think pulling the lens out a little further, we probably just disagree about the nature of law and the connection of law to morality and ethics and everything. So, we don't need to get into that to have this particular debate. But like what I want to do is sort of situate the context of what I hear Ryan say as being something that's very helpful from this policy perspective, where economics can tell us, what will create the kinds of incentives that we need or we want to put in place to achieve the things we want to achieve. I guess what I'm saying is what this sort of economic lens cannot tell us is what we want to achieve and why, and what the broader social implications of that might be. So there's a moment where we need to step away from that frame and have something else to deploy, right? And this is where I find myself, even in the patent example, being kind of frustrated with the notion that the best we can hope for here is that GSK might create an AI that might be able to solve all the world's problems, and so they deserve the patent. And I just wonder why. I mean, obviously it would be better if that amazing AI that solved the world's health problems was not privately owned by a corporation, right? Like obviously it would be better if what it created was a vaccine that everybody was free to use from the moment it was created, and that could therefore solve the global pandemic. So why we don't begin by thinking, well, what do we want to achieve? And then have the debate about whether the system that he imagines is going to get us there. But there are good reasons to doubt that the sort of economic approach that's reliant upon private ownership and monopolies and corporate interests and corporate profit-based incentives is going to get us where we want to go.
Well, those are great points. I'm kind of reflecting on them still. I don't know that I disagree at all with the principle that, prior to jumping into figuring out a bunch of rules, we should decide what it is we want out of a system and what rules would get us there and create it. And I think we're doing the same thing. I think, again, the issue is really less that we disagree on that framework and more that we are disagreeing on kind of what the underlying goals of the system are. And in fact, so maybe AI legal neutrality works for you as well as it does for me, even if it ends up getting us to two very different places, depending on what you preset the goals of the system to be. If you want a reasonable functional outcome, or if you want a, relational outcome, perhaps we could say. Right, and I mean, I suppose part of that turns into, you said, well, it would be much better if you had some publicly owned AI doing that sort of thing. I think that depends on your optimism or skepticism about market-driven solutions to problem, or government-driven solutions to problem. And I am skeptical that the government could come up with an AI that could do something like that better than GSK could. I mean, we won't get too political about it, but if you look at the system we had a year ago in the US, if you thought they would make that AI and make a vaccine cure, I'd be awfully skeptical. Of course, neither did GSK. So, we're not quite there yet. But if I had to bet on one, it'd be GSK over the US government doing something like this. And, certainly the system is full of many problems and, vaccine nationalism, and there have been lots of problems with IP and, but on the other hand, we have also seen, a remarkable development of several effective vaccines in previously unheard of timeframes. And so I don't know that the market-based solution to it has been, an entire failure. It did accomplish, one of the major goals, which was at breakneck speed to develop new effective vaccines, which it's done. And, even if we can improve the distribution and, equity in manufacturing those vaccines.
Ryan, Calo, please.
Well, this is a fascinating discussion. I'm sure glad I came back to catch it. So I guess I wanted to say a couple of quick things about this. So my quibble personally is merely with I realize that my quibble is really with the frame, and it's almost semantic, right? And so I want to bring you back to a time. And Ryan, I was actually a little surprised that you didn't engage with this work, but there's a book from years ago that I don't think is the authors are still mad at me to this day because I don't think it's the masterwork that they think it is. But basically, it's by Chopra and White, and it's called Legal Theory for Autonomous Agents. Ian and I both got into some sort of hot water by criticizing that. I will say, though, by the way, just for the record, if I come across something that I think is like facile about a topic I don't care about, I treat it with kid gloves, right? When it's by somebody who's very sophisticated and has put a lot of effort in and about a topic near and dear, that's when I'm very critical, because that's the work you want to invest your energy in improving. And I think Ryan's book is certainly in the latter category. So what I said about Chopra and White, what they did is they decided that we're going to have the law and policy take what's called an intentional stance. And so, Ryan, you talk about a version of the intentional stance in your criminal law discussion. But the intentional stance is this idea is we're going to pretend as though the things that AI was doing, it's doing on purpose. And we're going to do that instrumentally because we get better policy outcomes. And then they gave a bunch of examples of ways in which taking an intentional stance toward AI led to better policy outcomes. For example, the idea that, this is their example, the idea that gosh, it'd be better for Fourth Amendment purposes, because if AIs are combing through all of our stuff, if we treat that as intentional, then that would be like state action, and all of a sudden we can say that there's been a warrant requirement under the Fourth Amendment, right? But what I reminded them at the time was, sure, but what about the third party doctrine? If we treat spam filters as intentional, then we have committed our information to a third party that thereby weakens Fourth Amendment claims. You see what I mean? So if you are instrumentally simply saying, we're going to pretend as though AI is intentional because we like these policy outcomes, you know, what about when the policy outcomes are not what you want, right? Now, as Carys has already pointed out about Ryan's book, he takes a much wiser path. You take a much wiser path in my view, Ryan, which is that you say it's about a default that then you can deviate from that default. You know what I mean? You still have to explain when the deviation should happen. You also don't take an intentional stance. You take basically a functional equivalence stance, which is much better easily defended than an intentional stance. Still, I think you run into a problem where the characteristics of the law are so radically different when applied to this new entity that's not a person, that they cease really to be that thing. And I think your example of corporate law cuts the other way, because corporate criminal law is not like other kinds of criminal law. It is very cognizant of the fact that it's dealing with an entity, that the entity has certain forms, that you're double punishing because there are people that work there. I mean, it's radically different from other criminal law. We call it criminal law, it goes in the criminal system, I get that, but it's really, really different. You can also dispense with, you can introduce certain kinds of doctrines that you couldn't do with people, you can dispense with others. But for instrumental reasons, we've decided to develop a body of law for criminal corporate law, for corporations. Same here, right? For a bunch of instrumental reasons, as long as we take Omri and Carys and others, suggestion that you have a proper normative lodestar, right? Then we can come up with a variety of things that borrow from these elements. And so for me, it's really just what I bristle at, I guess, or what sets off alarm bells for me is the notion of neutrality, is the notion of equivalence. I just don't see them as equivalent or even capable of being so. And I don't see other contexts in which we have applied law to new entities. Like, for example, we pretend that ships are people in REM. You know what I mean? Like ships are people in property disputes. They have legal agency, but the law that attaches to that is radically different than that that we would assign to other sort of things. And so, I agree with the project I think it's much wiser and more sophisticated than previous instantiations of this method. But I do believe it breaks down. And I think that's why your criminal, like I must have read I think I read the criminal piece part too fast, because I was thinking you were trying to tell a story about how in criminal law too, we could apply criminal law to AI. But I understand in retrospect that you're saying, actually, here's a place where it's not wise. But even the reflex to say we could do it here too is obviously an effort to bring everything under an intellectual umbrella that you've created for your story about, you see what I mean? And so like that genuflection is must be a reflex of trying to go, equivalence and neutrality, even though you ultimately conclude this is one of the ones where we deviate from the default. So I'll shut up there, and thanks again.
Don't shut up yet, because I have a quick follow-up question for you, Ryan, Calo. Based on what you just said and your comment earlier, and I think this is a very, very important point for the general discussion of AI regulation, in a broader sense. So if we do agree, and I certainly agree that the equivalent is impossible, right? So making an equivalent between artificial intelligence and a human, and saying, well, listen, this is just a new a construct of a human, and let's apply law to this new being, as we did with human beings. I agree that this is very difficult to do due to various traits of artificial intelligence. But then what do we do? Because we are facing an era where this new embodiment, right, will be present in our human lives. It will be here. It will cause harms. It will change our social constructs, right, and arrangements. What do we do with it? And I'm saying this as a side note, maybe we should take another approach and just say, like, by the way, the European Union is doing right now with the proposed regulation, and say, well, you know what, we put aside questions of liability and criminal law, but we do want to regulate the process, right? We do want to tell you people, right, you human beings, you people who push us through towards this cliff of AI, how you should do it, how do we want you to do it, what kind of checks and balances we wanted to employ as a kind of a secondary, regulation or of how AI will behave amongst humans. So just happy to hear your thoughts on what could we do, assuming that there is no equivalent.
Sure. And I know we're over time. I'm happy to hang out and keep talking though, but is everyone else, we could keep going?
Yeah, I think we can do one or two more questions.
Questions. Well, no, Ryan, I do appreciate that a lot, and certainly appreciate the criticism. And don't worry, I'm very thick-skinned. I'm reflecting on this. I kind of answered this a bit earlier, but let me try and kind of rephrase that answer and think about how to make it appropriate. I don't disagree with some of these things. Certainly the law is very human-centric at times. You pointed out the Constitution, and because it fit into what we were doing, kind of pointing out the IP chapters, for example, in our district court hearing on whether you could protect an AI-generated invention, the patent office has now come out and said, no, you can't. There's no protection for this sort of thing. And it is because the Patent Act uses the word individual, which we think could only reasonably apply to a natural person and not any other sort of entity. And the argument isn't so much that we don't have human-centric laws, but that it is perhaps not wise to have laws that are so human-centric in this sort of way. And, so less as a statement of what the law is than maybe, how we should be thinking about the law or dealing with the law. And I think also a lot of it comes down to this distinction between treating humans and AI equivalently, which I am not in favor of doing, and treating human and AI behavior equivalently, which I am much more comfortable doing. And it is maybe a subtle distinction, but I think it's an important one, again, that you have AI and people behaving in functionally interchangeable sorts of ways, for example, generating innovation, and you wouldn't legally treat them as equal actors. You would not give an AI a patent. Not only would that require massive kind of restructuring of the law, but it just wouldn't be a good idea functionally or for a whole host of reasons. And yet it is the behavior that we want to encourage. We want AIs doing human sorts of things. We want them doing human sorts of things in ways that exceed people doing sorts of things. And we want legal frameworks that accommodate this. You know, with your tort comment, I'm not sure that that system doesn't work. You know, when we ask about causation, you know, this still strikes me as an objective discussion through heuristic devices. You know, I ran you over, did I cause it? Yes or no? And was it reasonably foreseeable to an objective person, not to you? We're not asking an AI, did you think you were going to hit that person? Or the drunk driver, did you think you were going to hit that person? Just looking at this now as a reasonable standard, you know, was this behavior reasonable? And if so, no liability. And if not, then yes. And I think that AI behavior fits really pretty perfectly into that mold. And there are good reasons to treat it that way. I think I kind of didn't frame the criminal law chapter as well as the others. You know, in part, this was an example of somewhere where it wouldn't lead to the right sorts of outcomes to treat an AI actor as being criminally liable, and kind of the difficulties associated with a body of law that was much less focused on functional outcomes than kind of intrinsic motivational outcomes. And so in some sense, the chapter was showing kind of the distinction between behavior and actor nature for focus of law, and also kind of one of the areas in which this didn't work quite as well in that. You know, but for the other areas, I think that this is something that our existing legal doctrines could accommodate treatment of, you know, sometimes perhaps with some statutory amendments, but other times fairly well as it is now.
I mean, I just want to jump in on that. I mean, there's two ways to think about the problem with proximate causation. There's what you know I've written about, which is the idea that if there's emergent behavior, it's hard to know who in the system could have predicted it, especially if it's you know, results in a harm of a different category than one is anticipated. But the truth is about the current configuration of tort law is that while it has in some ways been taken over by law and economics, whether they be Posner or Calabrese style law and economics, you know, notions about proximate causation are notions about fairness. They're not notions about, you know, why would we care whether you foresaw a harm? I mean, there's a line in your book about the idea that the victim doesn't care whether, you know, they still are hurt no matter whether it's this or that. Yeah, I get that, but like the law cares about whether the entity it's holding responsible could reasonably foresee something, you know. And if you decide that we're going to dispense with that out of an expedient because it leads to some optimal result of some kind, you really are changing the nature of tort. And I will say about taxation, which I don't know anything about.
Hold on, real quick before you move off that. Yeah. Well, I don't know that I disagree with that, and I'm still not quite sure why you think it's such a problem for me. And I agree with the fundamental fairness requirement there. But so a self-driving car runs over my foot and couldn't have realized that I was about to go put out a burning fire, and $10 billion in damages is caused, right? Wouldn't be fair to hold a driver to that sort of standard, you know, but that's, you know, objectively the case, not really dependent on what the AI algorithm was thinking. You know, we would again just be looking at this under an objective, what would a reasonable driver have foreseen, and running over someone's foot is not reasonably foreseeable as causing $10 billion in damages.
Yeah, I mean,
Ryan, I think, yeah, I just think that, you know, Ryan Abbott, given you're saying that eventually the liability would not be of the robot, rather of a, you know, of a human or corporate entity, then we still remain with the question of fairness, right, towards that entity, even if the standard of, you know, behavior or is attributed to the, you know, to the robot. So we're still stuck with fairness.
Right. Well, I mean, it would be right. The actual liability would always be with the company owning the AI, right? So it would always... but what's the difference then? In other words, why not just say, at the end of the day, when people do things with robots or they do things with pigeons, you know, you go to the doctor and you show them, and they do an X-ray, and the doctor shows it to a flock of pigeons, right? I mean, and then they come back and they say, I think you have you don't, or you do have this cancer, and you just say, okay, well, you know, I'm holding you, the doctor, to a reasonable doctor standard, and I'm going to modulate it, because now that every doctor has pigeons,
Right. No, well, I think
people
this
do higher standards. I mean, in other words, like, there isn't any need to do anything other than to say it's just people doing things, and what is reasonable as a function of the affordances available to them. And if they have a safety seatbelt, or they have a car that's better at detecting, you know, these kinds of things, then that will affect it. And similarly, if these entities end up doing kinds of damages that you couldn't foresee, you know, that is not a question about whether there's equivalence in terms of our treatment of AI behavior versus not. It's a question about whether the affordances of the environment blow up foreseeability as a viable construct, as a way to keep people safe and to balance compensation morally. In other words, it doesn't seem to be a conversation about neutrality so much as a conversation about what are the affordances of the environment now, and how do they interact with existing standards as they're applied to people. You know, so that's the only leap that you're making that I quibble with, is you're making a conceptual leap from people's affordances are different now with AI to we should be treating AI like, you know, functionally at least like people. I don't know that move is needed. And
Right.
and my other example, I was about to make this just very briefly. I loved your discussion of taxation. I don't know anything about it, but when you move from an income tax, a payroll tax, you know, obviously to people, and you then automate what they're doing, it no longer makes sense to talk in terms of how much you're paying the robot. I mean, what is an adequate substitution? How do you treat them functionally similar? It strikes me that you have to really rethink the nature of taxation to do that, which you should do because of all the reasons that you cite, and the fact that we have wealth inequality and we want to redistribute. But again, it doesn't seem to be a function of saying we're treating a robot Amazon worker differently, or the same or differently from a human. We're just saying that we're replacing an Amazon worker with a robot, and that is then changing the nature of how the business model works. And so therefore we should up the amount of taxation we do in another context. But again, it just seems like it's people doing things with robots. Does that make sense? I mean, that's what I'm struggling with. Yeah.
You know, those are kind of three issues, and I guess I should just tackle kind of the big major one first, right? What's the difference, especially in the tort scenario, between a person using an AI and using it negligently, or being negligent using it or not using it in the first place, and the AI being, you know, the locus of the behavioral analysis?
Mm-hmm.
Right? To me, doctors have always used all kinds of tools and technologies in medical care, and we are indeed holding a doctor to malpractice if they use pigeons appropriately or not. I mean, to me, the difference is whether the actor doing the behavior is a person or an AI. So, you know, for example, you go into an emergency room and your chest hurts, and I use EKG to see how your heart is doing, right? The EKG is not replacing the physician. On the other hand, if you're getting an app out on your phone and it is now providing an autonomous diagnosis, which, you know, Medicare has now approved for macular edema, you know, you get your phone out and it scans you and says you're having a heart attack or you're not. You know, there really isn't a human actor engaging in that sort of practice, at least, you know, not one to whom the AI behavior could clearly be imputed, even though people did develop the AI. I mean, they're functionally the actor doing the economic behavior that causes you harm is an AI. And so, you know, that model, which is not all AI, which is a very narrow subset of AI, at least at this point, is an AI functionally stepping into the shoes of a person and behaving the way a person would. And that's the sort of behavior that I'm concerned about in this. On the foreseeability thing, I think I'm just not connecting it here, because I'm not sure I'm changing that analysis, or that the way it is done, I'm disagreeing with what you're saying, but it is still an objective analysis of behavior and what would have been foreseeable, not what we think an AI would have seen as foreseeable. So I'm not sure how that changes. On the tax front, well, I agree. You couldn't sensibly literally tax a robot. You know, again, robot and human actors being different. You know, but their behavior is subject to two very different tax regimes, which has unintended consequences. And so getting rid of human-centric laws like payroll taxes would be effectively indirectly taxing robots and would create a more neutral system of taxation between automated labor and human labor. Not that you would say a Roomba gets a W-2 and is replacing a person.
I'm posting up a previous question from the audience, which I think we should address maybe as a final question before you conclude. And this was about the competitive effects, Ryan, in terms of IP, right? The interim period of IP, of patenting artificial intelligence systems and their outputs, and its potential anti-competitive effects, which is, I think, a valid point. And I think you addressed this at least briefly in the IP chapters, but it would be good to hear your thoughts on that as well. And I think we can conclude after that.
So let me go ahead and answer that. And first, just to wrap up on Ryan's points. Well, Ryan, I'm not saying you're wrong. You're very thought-provoking. We should have had the discussion before I wrote the book, but I'm going to continue to give this more thought. And I mainly wrote this book, because Carys wasn't aware of my work, but clearly, wouldn't have liked any of it. So this gives her something to argue against whenever she's going out and giving talks. So on the anti-competition front, this is something kind of Carys and I talked a little bit about, and I referenced earlier kind of another context that, maybe if we enter a world in which 5 companies hold every patent on every conceivable invention, we should have something like compulsory licenses, right? I mean, another means of dealing with that sort of outcome is antitrust or competition law. And so, it is not the case that IP exists in a silo by itself, and we have lots of competing sorts of laws and lots of contexts in which having AI could lead to anti-competitive outcomes. And so, perhaps there should have been a whole separate chapter in the book of this, but of course, we have to balance the normative goals we have for different bodies of law together. And even if you do have Google pumping out innovations at a breathtaking pace, this is something we want to address through competition law because other parties can't compete with it, and they're engaging in, monopolistic and anti-competitive behaviors, and that's not something we approve of. So I would say that, antitrust law is one means by which we can kind of better achieve our policy goals for having both innovation and fairness and distribution of new innovations.
Fantastic. Okay, so we're past our initial deadline, but this was fascinating, and I think I'm very happy that everyone left here bear with us for this. Carys, Ryan, and Ohad, thank you so much for your participation, for your comments, for the responses, and for this very rich and thought-provoking discussion. And we very much look forward to see the issue of the symposium published, hopefully later this year or early the year after. So we'll have the chance to read through the more robust comments. And again, thank you everyone for being with us. This was great.
Thank you, Omri.
Thank you again, everyone, so much for doing this, and for everyone who sat through the whole time and even went 20 minutes late. That was awesome.
Cheers.
Bye, everyone.
Congratulations,
Bye.
Ryan. This is a great book. Congratulations on it.
It is.
It's really.
Appreciate it.
Bye, everyone.
Bye-bye.